Good day. This is Immigration and Citizenship Attorney Perez Malakouti. Today is November 13th, 2025. And welcome to our 50th mobility space of the year, 50th and the last one. Today we're talking about the robustness of U.S. citizenship, and we're going to specifically be talking about Afroyim v. Rusk, which is a seminal U.S. Supreme Court case. So this is our final space of the year. Mobility Space is talking about the hottest topics in dual citizenship, freedom of movement, sovereignty, and of course, passports. And I have here today John Richardson. He's co-hosting the space. We're just going to have an open discussion, easygoing discussion, talking about some of the issues in the case of Afroyim v. Rusk. And I think probably most importantly, and maybe most interestingly to our guest, what does it mean? What are the practical implications? I'm not an academic or a scholar. I have an academic interest in these types of cases, but primarily I read these cases, I think about these issues, I research with the purpose of thinking about how this can result in guidance, practical guidance, both for my own clients and then just for other people out there that are in the same situation. I don't want to speak on behalf of John Richardson, but perhaps he's also looks at things primarily through the lens of what this could mean practically for others. So we have this story of Bellei Afroyim, okay, who is a Polish immigrant to the United States. It's not exactly clear when he was born, but sometime in the late 1800s, 1890s. He immigrated to the United States in 1912. He naturalized as a U.S. citizen in 1926, and then he went traveling. So he moved to Palestine, which later, of course, became Israel, and he voted in elections in Israel in 1951. A few years after that, so 1960, he decided that he might want to come back to the United States. And so he applied to renew his U.S. passport. And that's when this issue came up of the possible effect of him having voted in Israeli elections. His U.S. passport application was denied, and he was informed that he had lost U.S. citizenship when he voted in the Israeli elections under the 1940 Immigration and Nationality Act, specifically Section 401E, which provided for loss of citizenship for those who had voted in a foreign election. So obviously this started the case, right? So first administratively, and then of course litigation. Fast forward 7 years later, and Bellei Afroyim ended up in the U.S. Supreme Court, and he won his case in the U.S. Supreme Court. And that case, Afroyim v. Rusk, is now a seminal decision related to the robustness. This is my term, not a legal term, but the robustness of U.S. citizenship. And the way I define that is, how resistant is it to involuntary revocation, right? So the Afroyim case does not mention dual citizenship. I have referred to the Afroyim case as also standing for the robustness of American dual citizenship. It's not because dual citizenship is explicitly mentioned. It's not. But it has to do with the fact that, as we've spoken about before, dual citizenship is not a monolithically imposed status. Dual citizenship occurs by the independent combination of domestic laws of two different countries that allow a person to have, or either allow or impose, depending on how you look at it and depending on the circumstances, but allow or impose citizenship of two different countries on a person, right? The more difficult it is for a person to have their citizenship involuntarily revoked, right? De facto, I would argue, and of course, be happy to hear from other people, de facto, it increases the robustness of a dual citizenship or a multiple citizenship. So that's kind of how I look at Afroyim v. Rusk. And of course, we'll get into more details here. But a few questions I'd like to just throw out there. We don't have to address them right now, but just a few things that I think would be interesting to talk about. One is, how steady is the holding in Afroyim v. Rusk? How reliable is it? How likely is it that this could be challenged in the near or medium future? Number two, what is the holding in Afroyim v. Rusk? Right, that's something obviously we should talk about. And then on a more practical side, and possibly one might be might be of interest to American citizens, especially if they have future children forthcoming, is what does Afroyim v. Rusk say? What bearing does it have on your possible decision as an American to have a future child inside the United States or outside of the United States, right? I think that's relevant because Afroyim v. Rusk, kind of affirms that, and basically strengthens the right of citizenship per the 14th Amendment, which includes people that were born in the United States or naturalized. The right of American citizenship for people that were born abroad to U.S. Citizens is congressional. It's not doesn't necessarily find its rooting in the Constitution. So therefore, for people who are thinking about birth tourism, right? Some people out there might be thinking that, hey, one of the parents is a U.S. citizen. We already got U.S. citizenship for the child. That's in the bag. Let's go do birth tourism somewhere else to pick up the second or third citizenship. Well, if you want the highest, right? I mean, one way to think about it is if you want the highest, most robust claim to U.S. citizenship, maybe you don't want to have the child abroad to a parent of a U.S. citizen. Maybe you want to, trigger the protections of the 14th Amendment by having the child in the United States. So that's kind of a more practical consideration that I think would be interesting to talk about. And then also, there's some interesting points in the case. John Richardson on the IRS Medic podcast last week had an excellent presentation, and we'll be talking about and piggybacking a little bit on that presentation. But one of the interesting points was what was argued in both the briefs as well as the oral argument versus what actually came out in the decision afterwards. And the lawyer for the government in the U.S. Supreme Court oral argument, which is available in audio, very high quality audio, even though it's from 1967. But that lawyer tried to kind of sneak in some extra facts that were not in the administrative record. And for people who enjoy, hearing skirmishing back and forth in oral argument, there was quite a bit of annoyance, I think, on the part of some of the Supreme Court justices. So there's also some kind of interesting entertaining aspects of the case to talk about as well. We got good attendance here. We got John Richardson, we got Patrick, we got Jay, we got Adam, we got David, Lisa, and Nick, as well as our anonymous listeners. As a reminder to everybody, anybody can talk. We have these as open discussions. Just send a request and I will approve it right away. But I think that's it for my introduction. Let's start off. Let's bring John Richardson on here. Welcome, John. I'm going to start off maybe a little bit backwards, John, and we can work and work backwards from there. But I think my first question is going to be just straight to the heart of what I think a lot of people might be interested in which is, in my opinion, what are the practical implications, in your opinion, of Afroyim v. Rusk for somebody who's citizenship planning for their unborn child?
Right. So those are two, I think, very separate questions, actually. Let's start with, I think, what the case actually means. And it means two things, all right? And you're absolutely right that there's nowhere, as far as I'm aware anyway, in the judgment of the case that specifically talks about dual citizenship. To understand what it means, we always have to go back a little bit in history. And the United States, like many other countries, has a clear history of weaponizing citizenship and using citizenship stripping as a way to essentially get rid of people they don't like, for one reason or another. And what we were dealing with contextually was, in 1940, sort of a post-war suspicion of everything foreign, right? And this general culture that it was reasonable to expect foreign influence in the United States, people wanting to come into the United States, what have you, for nefarious purposes. So that led to, and this is very, very interesting if you look at the timelines, that led to what is now Section 349A of the Immigration and Nationality Act, which essentially listed prescribed reasons for why somebody would automatically lose U.S. citizenship, like no questions asked. Okay, you do these things, you're out. All right. For example, naturalizing as a citizen of another country. You're a U.S. citizen, you naturalize as a citizen of another country, you're out. You're no longer a U.S. citizen. And even after 1967, I know this living in Canada with a number of war resistors, Vietnam War resistors who came to Canada, who, were somewhat tortured, some of them, over the idea of becoming Canadian citizens because they understood that to be an automatic loss of their U.S. citizenship and other odds and ends of things. Okay, naturalizing. In Mr. Afroyim's case, it was voting in a foreign election. Other examples would be serving in the armed forces of another country, et cetera, et cetera. But to get to the answer here, what the holding of Afroyim is that it is unconstitutional for the government to strip a U.S. citizen by birth in the United States or a naturalized U.S. citizen from their U.S. citizenship simply by doing that and nothing more, right? So again, all right, pre-Afroyim, you do one of these expatriating acts. Doesn't matter why you did it. All right, arguably it mattered whether it was voluntary, but the reason didn't matter. And your intention with respect to U.S. citizenship didn't matter either. What mattered was that you committed the act. It was like a strict liability offense for those who like to analogize to criminal law. After Afroyim, the first holding and the most sort of public and understood holding is that the government cannot strip people from their citizenship for performing one of those expatriating acts without also showing that there was an intention on the part of the person to actually relinquish their U.S. citizenship, right? So, to take a very simple example, a U.S. citizen moves to Canada or Britain or somewhere, naturalizes as a citizen of one of those two countries. They should not have, from that point on, post-Afroyim, have been stripped of their U.S. citizenship. Rather, were there a determination that they voluntarily intended to relinquish their citizenship, then they would have lost their citizenship. So, right, that's the first practical impact. And, this was a great relief to an awful lot of people because there was agony over becoming, citizens of the country who they were living in. But I actually think that there's a more important holding in it that, oddly enough, is so obvious that it's never mentioned. And that is that there's constitutional protection to U.S. citizenship. That's it, okay? It's constitutionally protected. It is a constitutional right. Citizenship, if you will, is owned by the citizen and not by the government. And the government cannot walk around taking people's citizenships away. Now, if I were to ask you the question, we're a year from all the elections in the United States on November 5th. 2024, we woke up to a world where the Republicans control the House, the Senate, and the presidency, right? Could, a Republican-controlled Congress simply strip every Democratic member of their citizenship and kick them out of the country, right? I mean, you think that was ludicrous. But without constitutional protection to citizenship, although unlikely, that is a logical and legal possibility, right? So that's what the case stands for very minimally. Now, notice that the primary beneficiaries of this would be people who were not dual citizens from birth. Those who were born with dual citizenship from birth, for any of the number of reasons that we've discussed ad nauseum on these spaces, were affected by it only to the extent that, if they wanted to, they were now able to serve in the armed forces of another country or employment from a foreign country, but they were less affected, right? So this really was the recognition of that right. Now, that is to keep your citizenship. And I think more importantly, keep it, yes, but that you have a constitutional right to your citizenship that stands above what the government can do. And I think it's important to remind people of that, particularly in the current political climate, where the Trump administration has, in my view, began very serious discussions about whether everybody born in the United States is a U.S. citizen. All right. And without taking a position on that, the point is that the discussions have started. And I think possibly, even the issue of stripping people from citizenship, right? So that's what the case meant. The effects of it, though, I think are somewhat different. Like there's so many cases in the law, as you know, where, a decision has reverberating effects outside the context of the case. I mean, nobody in Afroyim was talking about citizenship taxation and the expansion of dual citizenship abroad and the expansion of the U.S. tax net, this sort of stuff. But that's actually been, I think, the principal effect of it. Now, we've had a lot of discussions on this, and and I thank you, by the way, for raising the importance of a lot of this stuff, because your space have caused me to think about dual citizenship more than I might have. But it's become incredibly clear to me that dual citizenship from birth is the way to go, and it is incredibly valuable, for all kinds of reasons. So Afroyim doesn't help you get dual citizenship from birth, right? But what it does do is it helps you get dual citizen after birth in the form of naturalization and keep it.
Yeah, absolutely. And, going back to your example of a completely Republican-controlled Congress possibly voting to strip Democrats of citizenship, the reason a right to the citizenship being rooted in the Constitution matters is because there's a much higher burden to amend the Constitution, right? That's basically the bottom line. It's not just a straight majority, right? It's 2/3 vote in the House and Senate, and then ratification by 3/4 of the state. So that makes it that more insulated. The right is more insulated to basically a change in the composition of Congress. John, what do you? I mean, some people out there, especially if they're fighting to be released of U.S. citizenship obligations, might have the opinion that Afroyim is negative because it makes it harder to lose citizenship. Do you think there's any merit? Do you think there's in that kind of view, or not really?
A little bit, not a great deal. I mean, pre-Afroyim, the performance of any of these expatriating acts, you go in and how would they know about this? You go in, you renew your passport. They ask, have you naturalized as a citizen of another country? You say yes, and they say, oh, well, here, have a CLN, right? We're going to strip you of your citizenship. The difference now, from a practical point of view, is that, if you want a CLN, right? If you want a CLN, I mean, let's be clear here. Loss of citizenship occurs through operation of law. Right. So the legal test now, of course, you can't just become a citizen of another country. You have to become a citizen of another country with the intention of relinquishing your U.S. citizenship. Right. But, if you've done that, you've lost your U.S. citizenship under the immigration laws without the government knowing about it or not. Right. The problem, of course, or the extra step now, from a practical point of view, is the probable necessity, at least for a lot of people, having to get a certificate of loss of nationality. And in order to do that, they have to prove now, the burden of proof is on them, that they have to prove that they, one, committed the expatriating act, which would be, let's use naturalizing as a citizen of another country, but secondly, with the intention of relinquishing U.S. citizenship. And of course, it's impossible to know exactly. We know in an intellectual sense the standard of proof, which is a balance of probabilities, okay? But we don't know exactly how that's going to be determined, et cetera. So, I can understand the sentiment, but it certainly doesn't mean that they can't get a certificate of loss of nationality, all right, to affirm their loss of citizenship. It does mean it's going to be more expensive, more time consuming, and less certain, though.
Yeah, absolutely. I think citizenship is so foundational, so fundamental to a person's ability to function in society that even if it's a citizenship that has really onerous, liabilities, a yoke around your neck, like citizenship-based taxation, in general, the vast majority of people, in my opinion, this is my opinion, are better served by having it be difficult, not difficult, but by having to have a defined process by which the person, as a practical matter, can actually lose it, versus not. That's the way I think about it, right? I mean, in Afroyim v. Rusk, in the opinion, there's a discussion of intent. Can a person be imputed to have intent if to relinquish their U.S. citizenship if they do something, an act like voting in a foreign election, that they know will result in the loss of citizenship? Or must intent be, more granular? There must be something that must be separately expressed, right? And obviously, in Afrin v. Rusk, the justices, at least the majority, came to the conclusion that you can't necessarily impute intention to lose the citizenship just by voting in a foreign election, right? That the two kind of have to be distinct. I think that's the way it should be. That's the way it has to be, because on a long enough timeline, and we're seeing this now with the Trump administration, everything related to citizenship is weaponized by governments. Not just the loss of citizenship, right? The loss of the ability to prove your citizenship, so issuance of documents, the inability or added friction to being able to renounce your U.S. citizenship. All aspects of these things get weaponized by government, right? So I really think something like citizenship, because it's just so foundational to being able to operate. There has to be like I don't know what the term would be, guardrails basically for big steps, in my opinion, right? Even if it means, for example, on the back end that, the abuse is going to be, okay, consulates slowing down taking appointments for renunciants, or consulates being slow to issue CLNs, right? That's a drawback, no doubt, on the back end, right? And perhaps in a world in which it was easier to prove that you lost citizenship by operation of law, those people that are renouncing would not suffer that way, right? But I think for most people, especially most Americans, right? The fact of the matter is, with the difficulties of U.S. citizenship, still most Americans do not want to renounce their citizenship. So I think as a whole, people are served. Americans are served by having there be much more friction for there to be an automatic loss of citizenship, even if it results in friction for the person getting proof of loss of citizenship to do other things, right? Whether it be to continue their life outside the United States, etc. And of course, my opinion is going to be informed by my experience, and John, you deal with. I get the sense you deal a lot more with people that are Americans that are outside the United States and trying to shed U.S. citizenship, so they can live their life. And obviously, we have a little bit of overlap, but my client base and consul base is more people that are either becoming U.S. citizens or are U.S. citizens adding another citizenship. But in either case, people who still want to keep their citizenships, right? So obviously, different practitioners will have different perspectives about the relative benefits and drawbacks of having it be this way. But let me ask you this. Let me throw this one out. I know I have an idea of what I think, but I really want to hear actually from you, John, for my own benefit. If you're advising somebody, if you're advising a couple, and one of the couple is a U.S. citizen, they want their child to have as many citizenships as possible, and they want the child to have U.S. citizenship. Okay, so let's foreclose the possibility that they don't want the kid to be a U.S. citizen. Are you taking the stance with them that you should have the kid in the United States to trigger the constitutionally protected U.S. citizenship, or are you taking the stance more that no, the statutory, the congressional statutory, rooted U.S. citizenship abroad is worth it for the opportunity of that kid picking up a second citizenship by being born in a foreign country. You have any take on that?
Well, a little bit. I mean, my take is that I do what helps them get the result they want, right? I mean, that's where the rubber hits the road. But it seems to me that there's two ways that this can be achieved. Okay, we'll go with the one that you mentioned first. So, we have a couple doing some family planning. They live in Texas. They decide they want their child to be born with dual citizenship, so they fly to Mexico, and the child's born in Mexico, right? And, dual citizenship is achieved in that way. And as you point out, that's not 14th Amendment citizenship. Now, where that goes down the road, I don't know, okay? But as you correctly point out, if it's not 14th Amendment citizenship, they can be stripped of their citizenship, okay? I would say, well, they may be able to be stripped of their citizenship. Okay, remember, there's still due process considerations in terms of how it might be done, but certainly it's not as strong as 14th Amendment citizenship. The other way of doing it would be, depending on, so you have one partner of the marriage who's a U.S. citizen, and one who has a second citizenship, and that second citizenship would allow for the citizenship by descent to the child born, right? And then you could have the child born in the United States and get dual citizenship, right? Depending on the law of the, of the other country. And I don't know, which is better? Well, I think, I don't know that there is a general answer. I think it depends on, what the other citizenships are that may be available, et cetera, et cetera. I mean, I see this. Let's take Canada, the simplest example of all. If we have a child born to a Canadian citizen in the United States, that person would have Canadian citizenship from birth, right? Same thing, I think,
Correct.
with the UK. I don't want to speak too quickly about, all these other countries, but I mean, certainly this is a possibility. I think, look, as a general principle, if we're a multiple choice, and if the question is, are you better with 14th Amendment citizenship or not, I'd say, of course, you're better with 14th Amendment citizenship. But that may not be possible, depending on the composition of the family, et cetera, right?
Yeah, and there's obviously all different types of profiles, right? But I think there are a few profiles that are common and really push the hard questions, right? One of those is, let's say both the parents are U.S. citizens, right? So the child, if born in the United States, I'm sorry, both the parents are only U.S. citizens. So if the child is born in the United States, the child would not be born a dual citizen from birth, right? But if the child is born abroad in a country that has jus soli, the child would be a dual citizen from birth. So the question becomes, right, is that access to the dual citizenship exemption from birth of IRC 877A, as well as the other benefits of dual citizenship, immediate highest right of entry and residency in a foreign country, second passport, all that. Is that, the question is that worth, right? Getting the statutory U.S. citizenship, not the 14th Amendment citizenship, right? And I'm going to make you squirm, John, because I know I do this to lawyers a lot, and I totally understand it. First of all, let me make a PSA. Everybody's situation has to be evaluated separately, right? Because even though we're talking about these things, we're presuming, I'm filling in assumptions and assumptions related to preferences. But the reality is everybody has their own set of preferences and priorities that has to be evaluated separately. So with that caveat, you, John Richardson, somebody comes to you, they say, these are our priorities. We value U.S. citizenship, robust U.S. citizenship for our child, okay, for the rest of their life. We also value having dual citizenship for the child from birth, okay, in case the kid, grows up and wants to renounce U.S. citizenship and exit the tax net, as well as other things. John Richardson, how much should we value that delta between 14th Amendment U.S. citizenship and statutory U.S. Citizenship in order to get the second citizenship from birth? Somebody asked you that question, John. How are you answering?
Well, I'd answer it, I think, in two ways. The first thing I would say to them, so I mean, my eyes are closed. I'm just imagining I have some young couple in front of me, right? Um, the first thing I would say is tell me about your own backgrounds. Are you entitled to any other citizenships, right? Say Irish, Italian, any of these things, Polish, Croatian. I mean, the list goes on and on.
Let's say
And
none of those. Let's say none of those. We know, let's say we somehow know as a fact the parents have only US citizenship, they're not entitled to any other citizenship.
so the question is what to do. I tell them to do what they could to get the dual citizenship.
Got it. So
Absolutely, I would. Why wouldn't you? I mean, you're not giving anything up.
well, you're giving up the delta in the strength
Well,
of the claim to
yeah, I
US
see.
citizenship.
No, I think absolutely. Okay, to be clear, okay, we got a lot of language floating around here. My opinion, and of course, these are nothing but opinions. But my opinion is that dual citizenship from birth is more valuable than the 14th Amendment citizenship. That's what you're asking me, isn't it?
That's exactly what I'm asking you.
Yeah, that's the way I see it. I don't even think it's close. Because I think we're a long way away. I mean, let me put it to you this way. By the time the U.S. gets around to, really stripping people who already think they're citizens of citizenship, just everyday people, you're not going to want to go anywhere near the country anyway. That would be my view. But look, make no mistake about it. And I really come along, around to this view unconsciously, right? Almost like I've been asleep. But I see dual citizenship from birth as the single most valuable gift you can give to your child. The single, because the point is that not only does it give you all the things that citizenship in that country might have, but it allows you to get out of the United States, right? I mean, look, let's be really clear here, and this may offend some people, but so be it, okay? As long as the United States has citizenship taxation and all these rules, the truth is it's a fiscal prison. Okay, it's maybe not walls and stuff like that, but it's a fiscal prison. Okay, and lots of people are going to be wanting to escape this, or at least have the option. Particularly as it gets worse and worse.
Yeah, I wanted to put you in a corner and specifically ask that question that you answered, and I agree. That's my stance as well. That the dual citizenship from birth has such great value that for not for everybody, right? There's some people that are going to be out there. They're going to say, no, we so much value the robust U.S. citizenship that the 14th Amendment citizenship is worth it. But I think for most people, especially the types that are in these spaces, the types that follow me, mobilely minded individuals, for most of those people, the dual citizenship from birth for the future child is going to be worth the weaker claim to the U.S. citizenship. I just wanted to hear what you thought,
Yeah,
and that's
I
what you
don't think
answered.
there's any. I don't think there's any question about it. And, I don't honestly. I don't even think it's even close. But I'll tell you what is interesting about the reality of this kind of discussion with people. Like you talk about this, from the perspective of somebody who, this is who you are. It's your DNA. Thinking about this kind of stuff, right? Um, which gives you a perspective that's very different. From the other night, I actually found myself talking with a young couple, where I think they were in Australia or somewhere, and you know, and so it begins with, well, she wants to renounce her U.S. citizenship. I said, oh, okay, but then I said, tell me, what's happening? I see you have your husband here. Do you have children? Yeah. Are they U.S. citizen children? Well, we never registered them, I mean, that's a separate discussion. But then I got into the problem of being covered expatriate and said, look, you got to be really, really careful here. And then they said, well, we don't think that our children would want to have anything to do with the United States. And I said, 20 years from now, look, 20 years ago, we never even would have been having this discussion about renouncing U.S. citizenship, right? The world has changed so much. We don't know where the world is going to be, 20 years from now. And I think that although citizenship options can be expensive, of which the U.S. citizenship is the most expensive citizenship option on the planet, but, multiple citizenships are incredibly valuable, especially from birth, right? I mean, this is another thing. These kids were dual citizens from birth. And this is the group, dual citizens from birth, that are least pressured to renounce U.S. citizenship, right? Because, they can avoid covered expatriate status. They can avoid having their assets stripped from them. It is a preferred kind of citizenship. Like what has happened is that these, the U.S. tax and regulatory regime has actually created what I would call a caste system of U.S. citizenship. The preferred U.S. citizens are those who are dual citizens from birth and frankly have nothing to do with the United States. They've hardly ever lived in the United States. They have no consciousness of, the regulatory regime, the taxes. I mean, they can hold a U.S. passport forever, without any of the problems. So that would be, those are, the Brahmins, if you will. To use that analogy, the untouchables, right, are the ones born in the United States with only U.S. citizenship and, 400 years of, ancestry in the United States, right, where they have no possibility of getting it. So, this is an extraordinary thing, right? I mean, taxation is destiny, all right? It's the organizing principle of societies, et cetera. And the point is that dual citizenship from birth gives you some control over that, because it actually gives you another place to go. And in the case of the United States, the ability to slam the door on it for good.
Yeah, it gives you the possibility, with other requirements as well, of course, but the possibility of a costless or low cost opt out, right? That's really what it is. It gives you the ability to exit. I call it the deep exit. I call the shallow exit physically leaving a country, the deep exit, the renunciation or relinquishment of the citizenship. That's just lingo that I use. The dual citizenship from birth gives you the ability in the future, the option to opt out with no cost or little cost. And it's not just I would argue that that's not just, an option that you keep for the future that's divorced from your, from your contemporary mindset. I had a post, a couple weeks ago where I wrote about how having those options that you can exercise in the future, even if you're not ready or even if you think you'll never exercise them, it trickles down into the psychological experience of freedom that you have now, because you know that you have the option, even if you're not going to exercise the option. And that's part of, I mean, this might sound pedantic, but that's part of the reason that I harp so much on the mantra, freedom of movement is the answer, not necessarily movement, right? Movement obviously sometimes has to be taken, but I actually go further and say it's the ability, it's the freedom to move. That's the answer, both in real terms as well as psychologically, as well as other things. So yeah, I mean that's what it's about. It's about collecting future options. I mean, you made the comment, we don't know what the United States is going to be in 20 years. Could be way better vis-a-vis CBT or other things. Could be the same. Could be way worse. We don't know. And even, I mean, the fact of the matter is, even so-called experts, prognosticators, even people who follow this stuff very carefully, nobody can really know, okay, with clarity and be sure, okay, even on the medium term, forget the long term, on the medium term, where a country is going to go and where a country is going to go with its obligations and extraterritorial obligations for its citizens. So as you, the consumer, the individual, the freedom-seeking individual, the strategy has to be options. Collect as many options as possible, especially, of course, low-cost options. Even if the potential benefit of the option seems low or seems low now, if there's low cost to picking up that option, you must pick up the option. And the example that I use is people who qualify for citizenship by descent in poor countries. I have this happen all the time. Less so now. I think there's actually because of education and more content out there. I see this less now, but still a lot. But I see a situation where somebody, consult or somebody else comes and they have what looks like a prima facie claim to citizenship in a poor country. Okay, a country that's not a desirable place to live in, but does not have what I consider the big red flags of second citizenship. So CBT, prohibition or renunciation, mandatory military service. And a lot of those people take the posture, why would I want that? I don't have any benefit for it. I don't see any view for it. What I see when I hear that is the world on a timeline, a long timeline, and nation states on a flywheel, a slowly rotating flywheel. Okay, nation state that's up yesterday is down today, and vice versa. And nobody knows exactly how the flywheel is going to turn, what direction it's going to turn, how fast it's going to turn, whether it's slowly or whether it's going to jerk. And so what I see is a missed opportunity, a missed option, basically, a missed option that seems like it has low value now, but it has very low cost and they're not picking it up, right? And so, going back to your point, right, it's the same concept, right, for the American dual citizenship from birth. We're not vilifying the United States. We're not lionizing the United States. We're saying what the facts of the circumstances of U.S. citizenship obligations are now and saying we don't know what's going to happen in 15, 20 years. So obviously people, I think the rational strategy is to do everything to maintain the option as low of a cost as possible. We got Brent here. I got to hear from Brent because I'm sorry to put you on the spot here, but Brent always has very, very insightful comments. What do you think, Brent?
Well, I was just going to go back to your hypothetical. I mean, your hypothetical was you had two U.S. citizen spouses, parents giving birth outside the U.S. And is it better to have 14th Amendment citizenship birth, or is it better to rely on the statute? And I was just going to say, if we're living in a world where you could have two citizens of a country giving birth to a child, and that child is not a citizen of the country of their parentage, if you will, that we're living in a very weird world, right? And one where you probably, at that point, the country's become so nationalistic, you probably don't care to be part of it because it's just weird. I mean, in my mind, the only issue that you're really risking is if you think your son or daughter is going to be president of the United States. And even there, I would say natural born means that you are a citizen at birth, whether by statute or otherwise. But there is a peculiar interpretation of that that sort of says you have to come out of your mother on US soil, which again, I think is a very weird interpretation of that. But nonetheless, in my mind, that would be all you're sacrificing because I cannot foresee a world where you would have the U.S. law say only people born on this soil are U.S. citizens. So that would be my answer to your question.
Well, it's not that people wouldn't that the child wouldn't have the citizenship. The question is how resistant is that citizenship to degradation, to revocation because of Congress passing an act. I think that's the issue.
Yeah, well, again, I think that's still, I mean, in my mind, I would think that's very unlikely that the Congress would pass an act that says, sorry, you were born to two American citizens abroad, therefore you're not going to be a citizen anymore.
Well, how about this? What if they pass a law that says if you were born abroad and you do these things, join a foreign military, you can now lose your citizenship? Afroyim doesn't protect that.
Parviz,
Yeah.
I'm going to chime in here. So the way that I read Afroyim, it actually seems to be a blanket prohibition on Congress stripping people's citizenship if the person's citizenship has been claimed or given out in any way. Whether it's based on birth or naturalization, as envisaged in the 14th Amendment, or a statute, I think that the protection that it gives goes out to anybody who's claimed their citizenship. It says here in the opinion the fundamental issue before this court here, as it was in Perez, is whether Congress can, consistently with the 14th Amendment, enact a law stripping an American of his citizenship, which is he has never voluntarily renounced or given up. So if we look at what the decision holds, that no, Congress cannot do that, I would interpret that as allowing for a rescission of a statute that grants somebody citizenship, but that people who have previously been granted citizenship by statute, even if the statute is later rescinded, those people would likely not lose their citizenship in any case.
Afroyim, kind of colloquially, generally, I guess you could say that like the broader imputed holding is that Americans can't be stripped of citizenship without their intent. But given that the bedrock rationale is the 14th Amendment protection, and the fact that the 14th Amendment relates to and grants citizenship to those born in the U.S. or naturalized in the U.S. I don't see. So first of all, the issue was not before the court, right? Of somebody who got citizenship statutorily. So
right, that's all dicta.
So any comment about that at most can be dicta, right? But I don't see what the rationale would be in Afroyim if the petitioner wasn't able to rely on the 14th Amendment because he naturalized in the United States. You see what I'm saying? What do you think, John? To Jay's comment, Jay brings up a great question. What does Afroyim really distinguish as much as perhaps we're talking about between those born in the U.S. Versus those born abroad to U.S. citizens?
Well, I think it does. Okay, but I understand that reasonable minds could differ on that. But I think that isn't there a subsequent case that specifically addresses that, where the ruling was that if you're born outside the United States to a U.S. citizen parent, it's not 14th Amendment citizenship. I think there's actually a case that speaks to that.
I think there is too. This is so unsatisfying. I hate saying this because I don't actually remember a case name, but I think there is as well too.
I don't remember the name of the case, but I'm pretty sure it's there.
Yeah, let's put a pin in that, and maybe I'll be able to find it later in the space. If I do, I'll definitely bring it up. But that's a big issue, right?
But good. Let's if you don't mind, and you wanted me to have a weird take, so I'll give you the weird take. I think if we go up to 30,000 feet here, let's just be honest for a second. These courts just make up this stuff, right? I mean, I know lawyers are never supposed to say that, but they just make stuff up based on the political winds and the way things are blowing.
Brett, that's
and in
my legal realism. You're a legal realist.
I am, of course, and I think that legal realism is in line with sort of prevailing politics and prevailing sentiment of society at the time. And I think the most interesting aspect, if you want my true opinion of this entire citizenship space, and I've been in this for a long time now, from let's say, is the unintended consequences of which is just plays out in every element of the older I get, the more you see it, right? Unintended consequences are 10 chess moves from where you are today. So if we sort of roll back the clock, to sort of, you can really trace it in my mind back to the UBS case and FATCA and all that sort of stuff, back to 2008. But if you think about even just Henley and Partners going down to oh gosh, I'm having a brain freeze for a moment. That country, and convincing them to do in the Caribbean, to convince them to do it, the Dominica, to convince them to do the citizenship based program, and then where we are today. We are so much a product of the fact that so much attention has been put on this space, and you have so many people on Twitter or X rather, and so many this notion of second citizenships and everything else. And as soon as you bring attention to something, right now you have, like, for example, the concept of if you have a citizenship based by investment, should you be denied a visa and all that, and it's all because attention and the spotlight is put on something where when it was quiet and when it was just under the radar, it was so much better. But yet we're living in a world where, just human nature, people get into this business, they can't help but keep quiet. They can't help but broadcast it, and then they broadcast it, and then you have the unintended consequence of closing the benefit that was there. And I sort of think if we're not careful, dual citizenship is going to end up in that same way, whether you're born, whether you get it from birth or not. I think if you look at these cases, if you look at the Afro case, the subsequent case, and you look at this notion, it was at a time when the U.S. was looking at a very expansionary view. It was courts that were looking at this thinking, we want an expansive view of citizenship. We're not being nationalistic. It's a very sort of, let's say, pro-American world, but not a closed border world. And I worry that if the case were held today, we would have a very different result, just simply because, from a legal, realistic perspective, from a political perspective, we have sort of a different mentality. So I guess my overall conclusion, I'm sort of rambling here, but I guess my overall thought is I think we should all just be quiet. I mean, I think if we're not careful, we're going to kill the golden goose, to the extent it's a golden goose.
So one thing, Brent, that is interesting, and Perez alluded to this earlier, is that the issue in Afroyim was very, very narrow, right? Or the factual predicate that got us there was voting in a foreign election, which seems fairly benign. But I would also point out that it was voting in a foreign election when he was actually not a citizen of Israel, because there was no such thing as Israeli citizenship at that time. Now, interestingly, the court in Afroyim easily could have just ruled that voting in a foreign election, if you're not a citizen of the country, is not an expatriating act. They easily could have done that, but they didn't. And the question is, why did they not? And I think the answer really lies, and if you listen to the oral transcript of the argument, Mr. Gordon, who argued the case for the government, was actually the lead litigation counsel for the INS at the time. So, I mean, this was a real heavyweight, really pressed the court to accept the fact that Afroyim voted in 2 subsequent elections after he had acquired Israeli citizenship. Okay, I think with a view to, very obviously with a view to getting the court to affirm Perez and Brownell, right, the predecessor case from 10 years early. And, I really have a sense, I'm interested in Parvey's view of this because he's listened to the case too, that had Mr. Gordon not irritated some of the judges so much by trying to get in stuff that wasn't in the transcript, I think the result of that irritation may have resulted in the court giving a much more expansive ruling than they might have if left to their own devices. Because, again, all they had to say was, look, what are you smoking? Okay, this guy was not an Israeli citizen. Voting is open to any resident of the country. All he did was just exercise an obligation available to any, or an opportunity rather, available to any resident of Israel. But they went way further. And the only reason I can see they went way further was because they just didn't like what Mr. Gordon was trying to do in the hearing. I don't know. Parvez, what's your view of that?
It's an interesting thought. I'd like to think that maybe that's what happened. I'm not sure. I agree that just the irritation caused the court to go broader with its holding than it otherwise would have. Yeah, I don't know. If you put a gun to my head and said, "Do you think that's what happened?" I'd probably say no. Maybe it's that misplaced confidence in the judges. Contrary to Brent's legal realism. But no, I don't see. I mean, do you have anything in particular, John, that makes you think that that was the case? Just the fact that the court could have addressed the case with a
No, it was the
1 hour
constant.
holding?
Yeah. Well, I was just listening to the hearing, right? I mean, this doesn't show up in the ruling, but it was the clear sense that certain judges of the court, particularly Fortas, really was unhappy with Mr. Gordon, for trying to get this stuff in, et cetera. And it was clear that he was trying to get it in because he wanted the court to, he was inviting the court to treat it as though the Expatriating Act was not voting in a foreign election, but what was somehow naturalizing as a citizen of another country. That's what I think he was really trying to do.
Oh, absolutely. Absolutely. He
Yeah,
was trying to get a last minute free option on another issue that he could win on. He's trying to insert a
exactly.
second issue that he thought he could win on.
Yeah,
Yes. So the judges were definitely irritated, absolutely. But I got the sense that they got so irritated because after they kind of chastised him lightly the first time, Mr. Gordon kept at it. He just kept trying. And I think that's what led. I mean, it was, if you listen to the judges, obviously, erudite legal minds, obviously justices, I really thought during the oral argument that they were really trying to give a good faith listening to Mr. Gordon, say, why is he, like, all advocates should know, like, this is not the administrative record. It's totally inappropriate to bring this up now. Why is it bringing it up? I thought they were actually trying to hear him out to figure out whether he's just, making a brazen attempt at entering a second issue, or if there's something that should catch, their attention. And his thing, I mean, when he was put to task for that, asked why is he bringing up this issue, his response was, well, I came to know this, I came into possession of this information, after the case had already, had an administrative record, and, in the interest of disclosure and candor, I'm bringing this to your attention. So yeah, they were annoyed, but no, I don't think, I probably have to listen again with an ear specifically to this issue to have a strong opinion. But I don't think I'm inclined to believe that alone was the reason. By the way, going back to Jay's question, Jay and John, the case that narrowed Afroyim v. Rusk is Rogers v. Bellei, 1971. Okay. And I must have been thinking about this case because I actually linked this 4 days ago. I linked the case to this tweet, actually. So this was a case in which a U.S. Citizen by birth abroad, outside the United States, so born in Italy, born Italian and American, basically lost U.S. citizenship because of not satisfying minimum residence in the United States after his birth abroad. And so the question was whether Congress could have a law that would obviously strip citizenship of somebody who got it from birth, but outside of the purview of the 14th Amendment. So Jay, there's the case. If you want to
Okay,
look it up,
thank you for
it's
linking
linked
that.
there. Yeah, of course, and bring it up, and yeah, if you take a look at it, and and come back, of course, if there's anything else that you think that's worth discussing about the narrowing of the holding.
But it's back to my legal realism. I mean, then we have this case Vance v. Terrazas, Terrazas, from 1980. Now, in this case, let's just be honest for a second. We're under the Burger Court, right? So it's a much more conservative court, and you have Justice White delivering an opinion that basically says, not wanting to contradict the past, but basically saying, look, in determining what is a proper standard for determining if someone's committed an expatriating event, Congress does still have the power, without violating the Constitution, to determine what the standard of proof is, right? In expatriation proceedings. And, the point simply being that the court giveth and the court taketh away very quickly, depending on political winds. And I think that is the key. Whatever we do, we should avoid a dual citizenship case going to the current Supreme Court. End of story, right? I mean, I cannot stress that enough. We are living on 5-4 decisions in a very precarious position, and it could easily go a different way.
That's a great point, Brent. I mean, the court can hollow out a constitutional right by imposing like a ridiculously high or ridiculously low burden of proof or something like that for some element, like intent. So that's a great point. Yeah.
Oh, it's fabulously good. They're fabulously good at being able to not reverse themselves. Absolutely. So, at the end of the day, I think, you just have to be wary of the political realities. And the political realities are such that if we're living in a more isolationist world and a nationalistic world, dual citizenship is a bit of an anathema to that, right? So, which I realize is sort of counter to what the tenor of the group is, of the space is. But I think it's important to interject that reality.
I don't think it's counter to the tenor at all. I mean, we talk a lot in our spaces about the concept of second citizenship privacy, right? Not being open with all citizenships one might have. And part of that is because one of the attack vectors could be, some sort of threat to the citizenship or more citizenships because of a change in the political winds in one of the countries or other. And that's something that absolutely has to be considered. That's definitely a realist, consideration that has to be had. And that's also possibly a factor in deciding where to have the future child, right? Because there's different paper trails related to the child's citizenship based off of where they're born. I had a tweet a couple weeks ago where I kind of went down the list of, comparing the respective paper trails that are made by a dual citizen from birth, born in the US versus outside the United States, right? In one case, the citizenship is of one country. Let's say, for example, let me just get more specific. Okay, so imagine a hypothetical a little bit different than the one I gave Jonathan. Okay, but let's say that the parents, one is a citizen of a foreign country, one is a citizen of the United States. Both would allow for the child to be a dual citizen from birth, irrespective of where the child is born. If the child is born in the United States, then you got the paper trail, you got a pretty robust paper trail of US citizenship, or at least strong indicia of US citizenship, right? So US birth certificate, their life in the United States, etc. And if if the parents don't apply for recognition, at least not right away, of that foreign citizenship, then you have silence on that. Okay, so we know by operation of law, right, that in the ether, the kid was transmitted both citizenships simultaneously when they were born, but in practice, in terms of what's signaled, what documents and information is put out there, including to people that might be, let's call it actors that might, be antagonistic to your dual citizenship, there's a difference, right? That kid, on the surface, might just be presenting as a U.S. citizen, right, and not a citizen of the foreign country, or vice versa. The same kid, okay, born outside the United States, right? If the parents don't file for an N600 or CRBA, consular report of birth abroad, or try to make a passport application for the child, right? Even though we know by operation of law the child acquired U.S. citizenship, to use the words of John Richardson, the practical effects of that citizenship are delayed, right? So yeah, I mean, Brent, I don't think that's at all. I mean, these considerations, everything has to be considered. We can't be locked in as lawyers just into the legal system and say, well, that's what the law says and what it doesn't say. Like, no, political considerations and practical considerations are absolutely paramount if you're an advisor, if you're a consultant, if you represent people that are making real deal decisions. So no, I thank you for
Well,
bringing
and
those up.
I mean, practically speaking, I mean, I've always told people, I've done it myself. I think the minute if you get another citizenship, you should reapply, even if you're far away from your U.S. passport renewal, but renew your passport in the U.S. Because that clearly negates any sort of evidence that you intended to lose your citizenship, because you've just taken an affirmative act to affirm your citizenship, travel to the U.S. on a U.S. passport. Take those sort of factual steps. I mean, if you want to be extra careful, disclose in your passport application, say affirmatively, I took another citizenship, but I nevertheless was not intending to relinquish my U.S. Now, maybe somebody might disagree with me on that, but the point being, at least renew the citizenship. Not the citizenship, the passport, I think, is a strong evidence that you were not intending to. But that case I cited was quite interesting because the person was a citizen of Mexico, as I understand the case. I have to reread the facts, but a citizen of Mexico in the U.S. And all they were doing was going in to get a certificate of Mexican nationality, and in so doing, they had to sort of affirm that they were still loyal to Mexico, and that was the whole issue in the case, is whether taking that whether taking that oath was enough to relinquish, which really brings up an interesting point, which is for how long the U.S. government has been hostile to its citizens and saying, we think you've lost it, right? We've been living in sort of the anomaly period where I guess, in a sense, and even there begrudgingly, that the government, has sort of accepted the sense that you can have, that the concept you can have dual citizenship. But throughout, I mean, there's just multitudes of cases where the U.S. government was even taking the case, right? I mean, like, why are you wasting your resources trying to trying to say this person's no longer a citizen? It really shows a mentality that I think can easily boomerang back.
So,
I
Brent,
think on that, it's really
to expand on the facts that you were pointing out here. It says while enrolled at a Mexican university in 1970, Terrazas applied for a certificate of Mexican nationality. As part of his application, Terrazas signed a statement renouncing, quote, United States citizenship, as well as any submission, obedience, or loyalty to any foreign government, especially to that of the United States of America, end quote.
But I think he had to do that, right? It was like form language, right? So it's one of those things where you're not really
for him to apply for this document.
Well, there's a case in 1984, Richardson, which is actually quite similar, coming out of Canada, where the court in those circumstances ruled that Richardson had lost citizenship. One point on the Terrazas case. I mean, I know there's a lot of there are a number of views out there that, and to some extent, it rolled back Afroyim by creating this, by saying that Congress could regulate the evidentiary standard on intent. But what Terrazas did do was made it very, very clear. I think it should have been clear, but I'm not sure it was, that the Afroyim ruling applied generally and not just to voting. So it was a very, very powerful statement of the 14th Amendment right to citizenship on the one hand, while on the one hand, creating an evidentiary standard that, many people were not comfortable with. It's interesting to me, to Brent's point about, the length of time the U.S. has been hostile to dual citizenship, and clearly that is a true statement. I mean, you could essentially write the history of the United States as using attitude towards citizenship as a proxy for it. But it's interesting that, this issue starts, obviously, sometime in the 50s. We have Perez and Brownell. We have the war on dissent in that case. 10 years later, it effectively becomes the majority decision in Afroyim. This is 1967. But the United States continues to strip people of citizenship after 1967 for a very, very long time. The only protection you had was if you had a lawyer, who knew about the Afroyim case. It's not until 1986 that they actually changed the law, right, the statute. I mean, think of it, 19 years later. It took them 19 years to amend the statute to bring it in line with the Afroyim and Terrazas rulings, which it clearly does. And even then, it wasn't until the early 1990s that the State Department adopted an administrative standard that people becoming, naturalizing as citizens of other countries were presumed to not intend to lose their U.S. citizenship. So, make no mistake that the U.S. always has been and is hostile to multiple citizenships. And, I think it's worth reemphasizing Brent's point that these are all 5-4 decisions, right? All 5-4 decisions. If this were argued today, I'm not sure, as sure as Brent is, that you get a different result, but I certainly think there's a possibility of it.
I think it depends on the facts, but I'm pretty sure. I mean, if the facts were bad, I'm fairly certain that I just don't think. I just think that the goalposts have moved. I think that we are not in a. I mean, look, as I read it, you have sort of a more liberal court prior to Burger Court, and since then we've been cutting back, right? So, is dual citizenship a liberty issue, or is it not? And I have not seen that the court since I've been studying the court, it has not been sticking up to liberty. I think the American government has forgotten. Now I'm going to get political here, but the American government has forgotten what the word liberty means, and we have abandoned liberty throughout. And I think that's clear in the court decision sense. So it's purely on that basis I'm so strongly wedded. But to turn my comments to a more constructive one, what is really interesting is I'm going to ask you guys, John, and everyone else. imagine the following fact pattern, because I find myself in this personally, right? Which is the continued transmission of U.S. citizenship. So my children are U.S. citizens, one because he was born in the United States, the other because he got it by statute. And the question is, I mean, although I don't live in the United States, I'm still fairly American, and I think our household is a fairly American culture. And so the kids, I mean, they're not 100% American, but they're what I would call international Americans, right? Well, they have not lived in the U.S. long enough to transmit the citizenship onwards, right? So I'm thinking about my grandchildren, which is again a bit, hopefully, decades off. But the question really is one of, should one encourage the child, my son, to spend the requisite time in the U.S. to be able to transmute the citizenship if he marries someone who's not from the U.S.? Should you encourage your daughter-in-law to go to the U.S. and give birth in the U.S. so your grandchildren are the U.S.? Or do you just forget the whole thing, which is odd as a grandparent? Now, that's a weird topic, but it's one that is, it's interesting to think about.
It's not a weird topic at all. I think what's fairly can be stated as a chaotic world, I think it's worth thinking about. But there are ways to solve this problem that don't require a great deal of thought. And one of them is just, I think I don't know you very well, Brent, but I think your kids are below college age, aren't they?
Yeah, the one is just going to college now, and he will be going not in the U.S.
Well, yeah. So one answer is just send them to school in the U.S., right? It's a presence requirement. I think there are all kinds of ways to create relatively low-cost, easy options in that regard, and I think it is worth doing. Look, to be clear, I think U.S. citizenship has value. Okay, I also think that almost all citizenships have value. U.S. citizenship has value. It's just that it's very, very difficult to maintain. But I think, education, or what they used to call edugration, okay, is a wonderful way to do this. I mean, that's why I think that, every family that has somebody graduating from high school in the United States should think about sending their kids abroad for college or university or what have you, to countries that have some kind of a pathway to residency and citizenship. Or another wonderful opportunity in vis-a-vis the U.S., Canada, and Mexico is the TN visa, where, think of this, right? So a U.S. citizen can go to Canada under a TN visa. They don't get permanent resident status, but if they have kids born in Canada, all of a sudden these kids have got Canadian citizenship, right?
John, that was about half of our last space, actually, was specifically talking about the concept Patience is Alpha calls citizenships for different seasons of life. And we spoke about the young adult portion, so 18 to 25 roughly, and that play of going abroad to a school where you can study, and the study period counts towards the naturalization eligibility pathway. Brent?
Absolutely. And these are things you need to do, most people are going to do anyway. And, I think this is important, but I don't think we have to turn it into a huge, huge deal, which would scare people away. I think it's just sort of, maybe this is a blog post or article you could write, 5 painless ways to give your family, your kid dual citizenship. Or something like this.
It's not entirely painless when you look at the cost of U.S. university.
I mean going outside the United States, right? For people who graduate in the United States. I was in Ireland in September, and I struck up a conversation with a family that was in Dublin, who were visiting Ireland solely because their kid was going to be going to one of the schools there. And, it was interesting. And they, in the conversation, they said, well, we're paying $20,000 a year for this versus, the schools they were looking at in the United States, something like $70,000 a year. I think that's probably what, or up, which is probably what Brent's imagining. But so you can do this. Let's say you save $50,000 a year, give the kid the $200,000 to invest, and plus, you can open the door to residency or another citizenship. I just think that this can be accomplished in a lot more ways that don't involve such a huge life decision. You know, you got to go to school somewhere anyway. At least I think that's how most people see the world, right? You know, plus you get the benefit of, what's that phrase, studying abroad or whatever, right? But these are low cost, simple ways, as long as you think ahead, right? To create
Right.
these kinds of opportunities.
It's very much like estate planning.
Right.
You
None
know,
of
you
this
have to
is
think
rocket
ahead.
science. None of this is rocket science. You know, if you're a parent of a child who's, let's say, 15, you talk to them about, what are your options for college? Well, you could go to school in the United States, or you could go to school in another country. And to some degree, it seems that for American citizens who live abroad, one of the challenges is if they want to keep US citizenship for their grandchildren, to actually be able to finance sending their kid back to the States.
Well,
Yes,
financing
yes,
education is always a challenge, right? I mean,
that's 100% an issue. Yeah. Sorry, John. I didn't mean to cut you off. I was just saying that is exactly
yeah.
that it would be exactly the issue. Is you realize, oh, he or she has to live in the U.S. for what is it, 5 years?
Oh, yeah,
When
yeah.
is that going to happen? Who is he or she is she likely to marry? And actually, my point is, I think that law ought to be changed, right? I think that's terribly stupid to say, you could say, oh, well, it comes out of a notion that if you haven't spent any time here, you don't have allegiance here. But if you look at a lot of European citizenship, it's literally just based on the citizenship of the parents. So as long as each generation keeps getting citizenship, you can keep it going for a long time. And, I think at the end of the day, the concept is, do you have any sort of allegiance or value towards the country you're a citizen of? And I would really go head to head in a debate with anyone who suggests that people who are living outside the country don't necessarily have allegiance or affiliation with the country, because my children, as an example, clearly do. They've never lived in the U.S., neither of them, and both of them feel again, international, I would say, but they feel that they recognize that part of them is American. And I think that is a real tricky aspect of that law. So if we were to ever have immigration reform that would adjust, I would hope that we would see an end to this notion that you have to spend 5 years in the country in order to transmute citizenship, because I think it's a really weird. And again, it'd be one thing if that was international norms, but it's not. There's plenty of countries that don't have that as the norm, just as there's plenty of countries that don't have birthright citizenship as the norm.
Well, this is
Yeah, I would.
exactly the debate that's going on in Canada right now, right? Or that has gone on under this, this Bill C3. I don't know. Parviz, do you want to outline what that is and what the issue is, or does it matter? I mean, it's an important example of this, right? What
Yeah, I mean,
happens? Okay.
sorry, go ahead, John.
Yeah, go ahead.
In broad terms, the issue is whether there should be a minimum physical presence requirement to be able to extend Canadian citizenship through generations. Because if there's not, then hypothetically the pool of Canadian citizens is just going to march. It's just going to grow and grow over the generations. Is that what you're referring to, Joe?
Yeah, exactly. And we're 1 week away. Today's the 13th, right? So November 20th. Okay, if they don't have that law through by November 20th, the result of that court decision takes effect, right? And there's basically no encumbrances on transmitting citizenship, to somebody born to a Canadian who was not born in Canada, right? So I expect them to get something through on that. But this is a big issue, right?
Right.
Brent, I mean, look at Ireland, right? There are probably more people. I bet there are more Irish citizens because of these citizenship by ancestry laws. There are probably more Irish citizens living outside Ireland than in Ireland.
Oh, I think that's a fact, and I don't think it hurts Ireland for that result. If anything, it probably helps, right? The greater dysphoria, is continues to have loyalty back to a country, and that's actually somewhat useful.
You know, if you ever go to Dublin, you must go to, they actually have a museum in Dublin celebrating their diaspora. You know, all these people that, you know, achieve great things in other countries. I mean, they celebrate this, right? It's the complete opposite of the, you know, the mentality in at least the United States and possibly more.
I would agree with everything that you guys have said. I would contend that America needs a grandchildren's law. Somebody, and I don't know how or whether any of you like this term, but somebody who's a quote-unquote heritage American who's been descended from Americans for 400 years, if that person moves abroad, at this juncture, their grandchildren, if their children don't spend any time in the U.S., would not be citizens. And to some degree, some of these folks will have a lot of affinity for and a large connection to the country.
It's
Yeah.
definitely, it's definitely
I mean,
a
at the end
problem
of the
area.
at the end of the day, you take this, you know, to its extreme, and the question, of course, comes really, you know, is very meta. It's, you know, what's the point of citizenship in general, right? And then what are we trying to what is the concept of what we're looking for with a citizen, right? Is it current loyalty, past loyalty? You know, I mean, is it just you know, you pass some sort of background check and we know you're vetted? I mean, what is the entire point of the thing? You know, it's you get there quite quickly with this sort of line of analysis.
Yeah,
Well,
I have.
I don't think anybody knows what citizenship is, and I think that's part of the problem. You know, you listen to a lot of people in the United States, you don't like the tax situation, just renounce. I mean, what do they think citizenship is? You know, just something you check a box or something? So I think the discussion has got to include that. But, you know, one other thought on not so much Afroyim, but Perez or Brownell, since that was really the prerequisite of it. After having read the Warren dissent, and I'd be interested in people's views on this, I actually think that the Warren dissent might be one of the first Supreme Court decisions that actually articulates that American citizens have rights. You know, this whole citizenship is the right to have rights sort of thing, right? You know, it's an incredibly important rights, liberties, you know, what have you, decision, just outside the context of citizenship itself. The fact that Americans do have these kinds of things, right?
Well, I am not, and I haven't read that, but I mean, I would just chime in, John, that the Warren Court and Warren in general was really where we get most Americans' concepts of the fact that they have rights come expressly from that period of time in those court decisions. You know, things as ingrained as Miranda, the idea that, you know, you're arrested, you have to be told you have a right to remain silent, all that, you know, right to a public defender and the like. A lot of what we think is, you know, at the time, habeas corpus, which has been generally chipped away at, but a lot of that comes from that era. And that's why I come back to this political piece, you know, I mean, since then, those have been gradually chipped away at. And so I haven't read that dissent, but I don't doubt it, because at the end of the day, I think we haven't had a pro-liberty, pro-American individuals liberty, citizen liberty court or champion since then. Now, I know some people will disagree with me. Some people hate the Warren Court. Some people hate those decisions. But, you know, in my perspective, we are, you know, it's been a real shame because we've lost that. And frankly speaking, we don't really have anyone in Congress that views that way. And we haven't really had anyone in the executive that takes that view. It's really lacking.
Yeah, another aspect of this that I think is very, very interesting is, you know, before the thing with Anthony last week and this, I actually reread the Afroyim case for the first time in many, many years. And I actually saw it differently in this sense that, you know, I'm looking at Black's majority decision, which is only 5 judges, versus Harlan's dissent with 4. The debate largely, I think, could be phrased in terms of the meaning of constitutional rights, right? In other words, what the majority is saying is the purpose of constitutional rights is to protect people from the government, right? And Harlan's dissent is really more, well, was the 14th Amendment ever really intended, to go this far, right? And it's almost as though Harlan is looking at it from the point of view of Congress governs the Constitution, rather than the other way around. So these cases are, I think, incredibly important also for constitutional interpretation anyway. What is meant by a constitution?
Yeah, John, it's been a long time since I read Perez v. Brownell, but I just pulled up the dissent, and some of what I remember from the dissent is coming back to me. And tell me if I'm off base here, but what I broadly remember the gist of it being is that citizenship comes from, quote unquote, the people, and the people is more represented by the Constitution. Citizenship doesn't come from the government as expressed by Congress and acts of Congress, and therefore, the citizenship right, being fundamental as it is, has to be, constitutionally protected. Was that more or less what you were referring to?
That's certainly in the right camp. There's no question about it. But there's also something else that's really interesting about the Warren dissent that we've actually talked around before. And I think it won't be too long before this is identified. But Justice Warren actually says flat out that people have the right to renounce citizenship in that dissent.
Yeah, that's right. That's right. It's coming back to me a little bit now. I remember that.
And that's huge.
Go ahead.
That's huge because we've got, in the Roger Ver case, right, we've got the U.S. government trying to take the position there's no constitutional right to renounce. We have in 2003 that Accidental Americans case, where, they were trying to argue that the $2,350 fee was exorbitant and therefore, unconstitutional, whatever. But the government responded with, there's no constitutional right to renounce, and the written decision in the case affirms there's no constitutional right to renounce, right? Or that at least, maybe it doesn't say that, but at a minimum it says it has not been demonstrated there's a constitutional right to renounce, right? So, I think that this Warren dissent, it is, after all, the dissent of a Supreme Court, the Supreme Court of the United States to ruling, is incredibly important. And if I were arguing there's a constitutional right to renounce, I'd start there, right there, with Justice Warren's decision, because it says a lot about citizenship. And really what it says is this, that people have a right to citizenship that the government cannot muck around with. It's theirs. They can keep it. They can renounce it. They can do whatever they want. And it's not the business of the government. That's really what the summary of it would be.
I think we might have to have another space specifically on the trail of common law related to right to renounce.
I think it'd be a really, really good idea because it is interesting. And then there's that issue, we have the 1868 Expatriation Act. There's this wonderful book about it written by Lucy Salyer, Salyer. I don't remember the title of the book, but she raises the question in the book. Essentially, it's a history of leading up to the 1868 Expatriation Act, right? But, she raises the question of whether that was ever intended to apply to Americans at all, right? Or whether it was just something like, you come to America, we're going to presume you have a right to expatriate to become an American only. But was that ever really intended to apply to American citizens already? That was the question that was raised. And it's not clear that it was.
Under the starry flag. Yes,
yeah, under the starry flag. That's exactly right. And, it's funny because I actually, I was down in Boston for an unrelated reason a couple years ago, 4 or 5 years ago, and she was speaking at the University of New Hampshire on her book. So I drove up to New Hampshire to hear the presentation. And, it was a fabulous presentation, on this whole issue. But I was definitely left with a sense that, the right of expatriation was an open question, at least from her point of view.
Yeah, the funny thing is to me, and we had an exchange on this, John, or I don't remember if it was in a space or where, but a year and a half ago. If if the right of expatriation, as thought of and discussed among legal scholars in the late 1800s and Congress, if it only applied to the right of people to renounce their other citizenships to become U.S. citizens, it's kind of funny to me for a couple of reasons. One is obviously the obvious hypocrisy, but U.S. Congress and the United States in general has more, we have competency to, on questions related, much more related to our own citizenship than foreign citizenships, right? That's the way it is for every country, right? So it would be kind of funny, and I mean, without having read all the background, obviously, and maybe we'll do another space, but it's just kind of bizarre to me, the concept that you would have a right to renounce your other. So from the American standpoint, you have the right to renounce your foreign citizenship to become an American, but not to renounce American citizenship to become a foreign citizen or for any other reason. But given especially the fact that we don't exercise in the United States competence over foreign citizenship matters. You get what I'm saying?
Yeah, but this is just, yeah, of course I do. But I mean, it's one of the earlier applications of U.S. extraterritorial law, at least in intent. I mean, I agree that it's a difficult argument to make, but it is interesting to me that, a historian who devoted such a significant amount of her life to writing that book and thinking about this, would raise that as a question.
Yeah, absolutely. If we do a space on that, maybe we can get her on. Who knows?
Give it a try.
There it is.
Give it a try.
All right, we've been going for an hour and 30 right now. It's 12:33 Pacific Standard where I am right now. This is our last mobility space, at least my last mobility space of the year. Other people are doing their others. I'm going to continue the mobility spaces after a pause, probably about a month, 6 weeks. I'm going to reformat, right? I do want to give John a shout out, John. I started these spaces because of your spaces that you started, I think in February, if I'm not mistaken. I said, this is a really great conversation format, and I got to do this, myself. So shout out to you. You did inspire actually this series of spaces, which I can't believe it's been 50 already, but it has been, and we're going to continue. Any last thoughts or any other aspects to continue? Obviously, we can have future spaces addressing, specific issues of Afroyim and related issues. But anything else you want to talk about, John, or anybody else before we wrap this one up?
No, I think that the only thing I would say is that I think that we're in an era, and you made this point a while back, that thinking about citizenship is going to be more and more important. And there's absolutely no question. I sent you a link to an article from November 10th, right? You probably haven't had a chance to look at it, but the Trump administration has essentially declared war, on the idea of birthright citizenships and other things. And I don't think they're going to be successful on it, but what they are going to do is they're going to raise the consciousness of the importance of citizenship, and I think that's a good thing. The other thing that the general evolution towards global mobility has done is made people aware of the possibility of multiple citizenships, which I think is probably a good thing as well, largely for, what you pointed out today was sort of the psychological component to it. I think in life, often you get what you kind of expect. So the idea of multiple citizenships gives people an expectation of better freedom and more options. So, that's important as well. And, I think if we were to have this conversation a year from now, I expect that there's a lot of things we probably could add, which are likely to happen in the next year.
Yeah, absolutely. So I did actually get a chance to read the article. I linked it to this space tweet. It's called the Citizenship Fights Potential Next Targets. And the upshot is that the article claims that the Trump administration is going to make a play on trying to degrade 14th Amendment citizenship rights by claiming that within the jurisdiction of the United States excludes parents who have a foreign citizenship, right? And I don't want to get too much into the, further into the technicalities of it, but that's the upshot of the argument. I definitely agree with you, John, that the Trump administration's attempts raise the consciousness about citizenship. I hope they're not successful. I don't think they will be, but I don't want to, let my guard down. And I think people have to keep the guard up. And then as a practical matter, I mean, this might be a little bit more granular. One thing that the Trump administration can do, and I think they're going to be able to do with varying levels of success, is make it difficult for people to prove their citizenship, right? And that's also going to raise this other issue that John, you and I have spoken about before, and I've spoken about a bunch of times, which is the difference between the thing and the proof of the thing, right? And I think in the consciousness of the vast majority of people, they're the same. And why would they be otherwise, right? I mean, people don't have time. They're living their lives, unless they're lawyers or involved in this. They don't have time to be going into these kind of technicalities. But the fact of the matter is, these are very different things, okay? Citizenship transmitted by acquisition, by operation of law at birth, happens in the ether, happens automatically. No forms required for the thing to happen. But forms are required for you to get proof of the thing happening. And that's a very difficult thing for people to wrap their minds around, right? And so what the Trump administration can do, and what they've been trying to do, and I don't think we've seen the end of it, is to try to deny that proof of people who have a right to US birthright citizenship. So deny passport applications, redo passport applications where it starts trying to make an inquiry into the status of the parents, okay? These types of things, okay? And as a practical matter, so we're not talking about legally, but as a practical matter, if you have a thing, citizenship or any other legal right, but you don't have sufficient proof of the thing, well, then you're deprived of the ability to enjoy the benefits of the thing, right? And that can last a month, 2 months, a year, 2 years, whatever. That's volatile, okay? Like how long those types of effects can happen, but it has a real effect on people's lives. So yeah, I don't think we've seen the end of that. So I do think it'll be a bumpy road, to the end of the administration vis-a-vis the robustness and the security of U.S. citizenship, especially 14th Amendment birthright citizenship of children that are born to parents that have either no status or have non-immigrant status. But I do think, and I have faith, Brent's not here anymore. Maybe he would push back and say, no, you got to be a realist. And he brought up great points. But I do have faith that eventually, if this issue ever reaches the Supreme Court, that they'll come down on what I could perceive to be the proper interpretation of the 14th Amendment birthright citizenship.
Well, I think that probably they will, but nothing is certain. The point that Brent made extremely well, and you just made it, but I think it's so important that I want to make it again, is that these issues are a search for proof and not a search for truth, okay? That's the way this stuff operates. I mean, it's the problem that, for example, a lot of American citizens of a certain age in Europe may have, being able to prove citizenship to get a social security number and this sort of thing. So, proof really is the issue here. You made a point, an incredibly mindless point, and I love mindlessness because I think that speaks volumes, is that it's a good thing for everybody to get a copy of their birth certificate. Not that difficult to do, very, very inexpensive, but people ought to be doing that so that they're able to actually prove this stuff. And to your point about, I don't think you put it perhaps as strongly as it should have been put, so I just want to add to it. I mean, in January 2025, the Trump administration, as I understand it, instructed people of the State Department to not issue passports to certain kinds of people. That was my reading of it, right? How you identify those people, I'm not sure. But the point is, if you control the machinery of government, you control the process that should, lead to the issuing of passports, visas, things like that. I mean, if you look at any immigration space, I mean, they're always updating the process, to get a visa for this or that, or how long it takes, etc. So the law is interesting. I think it's a good starting point, But the law is usually, I mean, unless you got it into the courts years later, not where the rubber hits the road.
John, you're going to make me go on now for another 10, 15 minutes because you touched on some sensitive points that I'm liable to go on rants about. That's absolutely right. Absolutely. People have to understand law flows from legislators, politicians at a political level. But the tools of proof for rights or privileges under those laws are gate kept at the bureaucratic level. It's a huge, huge difference. Huge difference. Okay, you need citizenship in order to live, to travel, to function in modern day life. And in order to prove that citizenship, you need vital documents, passports, sovereign-backed legal IDs. Okay, so if you don't get the tools, and those tools can be denied at first level by bureaucrats, right? So I always say at first instance, to get this point across to people, I kind of take a little bit of I say a little bit of an extreme statement, right? Which is at first instance, meaning when you're dealing with bureaucrats, the law doesn't matter. And what I mean by that is that if you're denied unlawfully by somebody at a bureaucratic level, administrative level, in order for you to reverse that, okay, in order to be able to enjoy the rights, you have to pursue the right. Okay, you got to appeal, maybe admin appeal first, okay, then a judicial appeal if that fails, et cetera, et cetera. You got to put time, money, and stress into the process to reverse that bureaucratic low-level decision. So I say, I mean, it might be a little bit too extreme, but I say, I mean, the way you got to think about these things is, you're not going to be, if you're dealing with a bureaucrat, whether they did it mistakenly or whether they did it purposely but unlawfully. In the case of, for example, like you said, Trump instructing DHS to not give passports to certain people. If you're dealing with that, okay, you're not going to argue with them and win because you throw a statute at them or you case law or a brief and say, hey, this you're wrong here. I mean, you might if it was a mistake, right? But the fact of the matter is, you need recourse, and recourse takes time and money, and most people just don't have that time and money. That's just a fact. That's why so many issues never make it, bubbling up the federal court system, to either the circuit level or all the way to the Supreme Court. So as a result, as a practical matter, if you're somebody out there, right, I always try to do these spaces from the perspective of what does this mean for the sovereign individual, the aspiring sovereign individual? What this means is you got to stock up on the things that are used as proof for the rights that you need to live your life. So birth certificate, vital documents, passports, 2 from the same country if you can, like in the United States. You can get a second passport valid for 4 years if you can show the need for it. And passports and decentralization of your travel documents by passports from multiple jurisdictions. Oftentimes you need a second citizenship to be able to get the passport, right? And all of that strategy reflects, the reality of bottlenecks at an administrative level, at a bureaucratic level, that require time, money, and usually lawyers in order to break up.
Yeah, you talk about the cost of getting these things into courts and that, and since we're talking about Afroyim, it's pretty clear to me that the lawyers in this case sought out Afroyim. Okay, because they wanted to re-argue Perez versus Brownell. There is no chance that somebody like Bellei Afroyim could possibly have found the quality of the legal counsel that was necessary to get this case before the Supreme Court and argued. I mean, he was lucky. He was the right litigant at the right time, I think, for a group of lawyers who wanted this issue litigated. So he's, 0.001% of humanity. Most people, there's a saying that, even a dog knows whether he's been kicked or tripped over. Most people think they've just been tripped over. I mean, unless you really understand the law, you have no idea whether the stuff's being applied correctly or not, right?
Absolutely. Okay, John, I want to thank you for co-hosting this has been a fantastic discussion. You're a treasure. You're just an amazing resource for Americans abroad, American dual citizens, and so I really appreciate your time today. I want to thank everybody else who participated as well. Jay, Brent, of course, everybody who listened. We are going to have more spaces. We're going to have more spaces, more probing discussions. If you found this interesting, you're right, John. It is in my DNA. I think about these things all the time. I get the sense you're the exact. I get the sense you're the same. And so
I think it about it a lot. And Parviz, listen, I want you to know how much I appreciate you and your work. Okay, it's fantastic stuff, and you're the kind of guy who I honestly think you make all these lawyers and everybody around you a better lawyer. So thank you for that.
I appreciate that, John. Thank you for the kind words. Overstated, but thank you. Okay, so this is the last mobility space of the year, number 50. Reminder, 4 to 6 week break. I'm going to reformat the space and the show. In the meantime, make sure you follow John Richardson if you don't already. He's always putting out great info. And I hope everybody has a great rest of your week. Take care.
Thank you.